ಮೇಡಮ್ ಕೋಟಾಲ್ 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಮ್ಮ?
ಹಾ ಕೇಳ್ತಾ ಇದೆ.
ಓಕೆ ಸರ್. ಇಲ್ವಾ ಆ ಚೇಂಬರ್ ಬರ್ಬೋದು. ಪ್ರಕಾರ KSRTC ಮಂಡ್ಯ ಟ್ರೈನ್ ಹಾಕಿರೋದು ವಕಾಲತ್ತಲ್ಲಿ KSRTC ಬೆಂಗಳೂರು.
ನರಸಪ್ಪನವ್ರೆ, ನರಸಪ್ಪ ಇದ ಹಲೋ ಕೇಳ್ತಾ ಇಲ್ಲ, ಮ್ಯೂಟಲ್ಲಿ ಇದ್ದೀವಿ.
ವಿಘ್ನೇಶ್
Article 470. Article 470 put three. We could list cyber. At least two. Page wise adjournment, list number 2, page number 1, serial number 1 to 3, page number 2, serial number 4 to 8, page number 3, serial number 9 to 13, page number 4, serial number 14 to 19.
Says at the request of the memo filed for dispensation of notice to R2. Memo is taken on record. Dispense delay of 158 days is condoned, not entitled for the interest. The request refer the matter to local.
Page number 5, serial number 20 to 25. Page number 6, serial number 26 to 32.
Well, serial number 26 ಮೇಲೆ ಇದರಲ್ಲಿ ಡಿವಿಜಿ ಅವರು ಹಾಕ್ತಾರಂತೆ ವಕಾಲತ್ತು ಇದ್ರ serial number 20 ಡಿ ವಿಜಯ್ 26.
Yes, 26 at the request of counsel for the parties release this matter next week.
ಅಲ್ಲ ಡಿ ವಿಜಯ್ ಕುಮಾರ್ಗೆ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಮಾಡ್ಬೇಕು ಸಂಬಂಧ.
Yes.
ಡಿ ವಿಜಯ್ ಕುಮಾರ್.
Yes. D. Vijay Kumar is directed to take notice for respondent. The first delay of 2 days is filing an appeal is condoned. Respondent sir unrepresented. D. Vijay Kumar is directed to take notice for respondents. Yes, which is that? 28. Yes. Janardhan Reddy appearing for respondents press week's time. Yes, release this next week.
Malad, serial number 66, list number 2, Malad.
ಒಂದು ನಿಮಿಷ ಸರ್, ಪೇಜ್ ವೈಸ್ ಹೋಗ್ತಾ ಇದೆ. ಪೇಜ್ ನಂಬರ್ 7, serial number 33 to 38. Page number 8, serial number 39 to 46.
45. Where is that? His name is not shown. Let us see if the matter is released.
Page number 9, serial number 47 to 55.
40. Yes. Yes. At the request of counsel for the appellant, release this matter after 2 weeks. Permanent counsel for respondent submits that this appeal may be called along with the counsel. Yes.
Page number 10, serial number 56 to 65.
The counsel for the appellant submits that the insurance company has filed an appeal in MFA so and so is pending before the division bench. In view of the above, office is directed to post this matter before the division bench having in a roster after obtaining necessary order from Honorable Chief Justice. Duty? You inform that other side. Yes. Yes, at the request of counsel for the respondent, release this matter next week. Yes, office is directed to secure records.
Page number 11, serial number 66 to 68.
Serial number 66, Malad.
Yes.
Malad,
Yes,
the matter has been compromised, Malad, by the parties, Malad. ಅದಕ್ಕೆ ಅದು ಅಮೌಂಟ್ ವಾಪಸ್ ತಗೋಬೇಕಾದ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ will file, Malad. Before the execution petition, they have compromised and they have paid the entire amount, Malad. ಅದಕ್ಕೆ
Yes, yes. When do you want?
first week of Malad, November, Malad.
Yes, 3rd November.
Obliged, Malad.
68. Linkraj last year argued. He said that Alala or Amel Bandro, he said some amount. They are agreed for that amount. Let us. He said 70,000 ಏನೋ ಅಂತ ಅಂದ್ರು ಅವರು ಒಪ್ಲಿಲ್ಲ ಆಮೇಲೆ ಬಂದು they said 70,000 he can be agreed ಅಂತ ವಾಸ್ ಲಿಂಗರಾಜ್ ಎಲ್ಲಿಗೆ ಹೋಗಿದ್ದಾರೆ? ಟುಮಾರೋ ಮಂಡೇ ಸಿಟಿಂಗ್ ಇಲ್ಲಲ್ಲ. ಟುಮಾರೋ ಮಂಡೇ ನೀವು ಬರಲ್ಲ. ಎಸ್.
Number 1, hearing interlocutory application matter, serial number 1 to 34.
Notice.
Admission matter 35 and 36.
Notice.
Number 2, for order, serial number 1, Sanjay Gowda Inna for appellant, YP Venkatapati.
Yes. Notice to R2 is dispensed. Delay of 310 days is condoned, not entitled for the interest. Yes, ready. Where is that Venkatapati?
Serial number 1, YP Venkatapati.
Only future prospects. What about that? 2014. Yes. That is the only ground. What about that? This thing, liability, there is no dispute. Dependency, love and affection, 45,000. That has to be reassessed. Yes. Three, Sanjay Gowda, Learned Council appearing for the claimant has contended that in view of judgment of apex court in case of Pranay Sethi. What is his age? That in view of judgment of apex court in case of Pranay Sethi, the claimants are entitled 40% of the income of the deceased for future prospects. The tribunal has not granted any compensation under that head. Secondly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 44,000 each. Hence, he sought for enhancement of compensation. For contra, YP Venkatapati, Learned Council appearing for insurance company, has contended that the claimant has failed to establish their income. Not establish their income. The tribunal has not granted any compensation for future prospect. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. There's judgment and award. It is not in dispute with the name of the deceased. Mr. Mohan Kumar died in road traffic accident occurred on 17/7/2014 due to rash and negligent driving of rider of motorcycle bearing registration number AA01H5047. Even though the tribunal has assessed Delhi the tempo. Yes. Tempo bearing registration number KA035104. Even though the claimant, the tribunal has assessed that notional income of the deceased in view of judgment of apex court in case of Hemraj case. even in case of notional income, even in case of the income was been determined on a guesswork, the claimants are entitled additional 40% income for future prospects. In view of the judgment of apex court in case of pranay seti, 40% of the income of the deceased has to be added for future prospects. At the time of the accident, deceased was aged about 28 years. The multiplier applicable to that age group is 28 is 17, 18 hakidara. 17, yes, 17. Since deceased was a bachelor, 50% of the income of the deceased has to be deducted for personal expenses. Accordingly, loss of dependency has been reassessed as follows. The income assessed by the tribunal, 9,000. Yes.
$3,000 plus 3,600 at the rate of 40%, 1,600 minus 6,300 at the rate of 50%, 6,300 into 12 into 17, 1,85,200.
In addition, 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of Magma, who is that first claimant? Who is third one? Yes. Claimant number 1 and 2 are entitled 44,000 each for Finyl consortium. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. In view of order dated so and so, the claimant is not entitled for the interest for a period of 310 days.
Number 2, Vishwanatha K for appellant, Harini Shivananda. Number 2,
Notice to R1 is dispensed. Delay of 104 days is condoned. Yes, Harini Shivananda. Ready, madam?
Ready, sir.
Yes, Mr. 2017.
10,000 ತಗೊಂಡಿದ್ದಾರೆ 11,000 ತಗೋಬೇಕಾಗುತ್ತೆ.
Yes. Yes. Disability ಎಷ್ಟಿದೆ? Disability ಎಷ್ಟಿದೆಯಪ್ಪ? Correct.
8% to whole body ಅಂತ ಹೇಳಿದ್ದಾರೆ, 5% ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
Where is that discussion? Disability. First, disability left lower in the 28% to the extent 8% whole body. Consider the cross examination. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಪ್ಪ? 5 days. Pain and suffering, medical expenses, income during the later period of a treatment of disabilities, communities, nourishment. Yes, yes, that's all. Three. Okay. Learned counsel appearing for the claimant has contended that at the time of the accident, he was earning 20,000 per month. Tribunal has assessed 10,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. He has examined the doctor. Doctor has assessed the whole body disabilities. Doctor has deposed that the claimant has suffered 25% disability to particular limb, 8% to whole body. The tribunal has assessed whole body disabilities 5% is on lower side. Lastly, he has contended that due to that extent, the claimant has suffered grievous injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Srimati Harini Shivanand, learned counsel appearing for insurance company, has contended that even though the claimant has claimed that he was earning 20,000 per month, produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 10,000 per month. He further contended that tribunal, after considering that the evidence of doctor and injury suffered by the claimant, has rightly assessed whole body disabilities 5%. Lastly, she has contended that the injuries suffered by the claimants are in minor in nature. He was inpatient for a period of only 5 days. Considering that the evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for dismissal of the appeal. Or the learned counsel for the parties arose judgment and award. It is not in dispute. The claimant suffered an injury in a road traffic accident occurred on 5/9/2017 due to rash and negligent driving of driver of car bearing registration number KA03 AD 8009. Due to that accident, the claimant has suffered the following injury. He has examined Dr. Rahul P. as PW2. In his evidence, he has deposed that the claimant has suffered 25% disability to left lower limb, 8% to the whole body. Considering that the evidence of doctor and injuries suffered by the claimant, I am of opinion that whole body disabilities can be assessed 8%. At the time of the accident, it was aged about 30 years. The multiplier applicable to that age group, which is 17. Even though the claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Other circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income has to be considered as 11,000. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that the evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 40,000, loss of immunities from 10,000 to 30,000, loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in court.
Number 3, R. Shashidhara for appellant, HC Betsur.
Yes. Notice to R1 is dispensed. Not entitled for the delay for a period of 160 days. Yes, Mr. Ready? You want time? Next week. Office is directed to secure original records. Hmm. Hmm. Okay. Submission of learned counsel for which respondent, Mr. R3 is accepted. Wakalat filed on behalf of the respondent number 3. Office is directed to accept the wakalat filed on behalf of respondent number 3. Yes. ನೀವು ಹಾಕಿದ್ದೀರಾ ನಿಮ್ದು ವಕಾಲತ್ ಫೈಲ್ ಫಾರ್ ಸೋಲ್ಡ್. ಎಸ್ no, first this matter who is appearing, Mr. You have to decide and ವಕಾಲತ್ತಲ್ಲಿ ಇಬ್ಬರಿಗೂ ಕೊಟ್ಟಿದ್ರ then who has to decide? Yes, by next time you decide who is appearing. Yes. ಎಲ್ಲಿದೆ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ. Connected matter ಅಲ್ಲಿ it is a different person, same climate. ಆಯ್ತ್ರಿ, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಕೊಟ್ರೆ ಅವ್ರ ಫ್ಯಾಮಿಲಿಗೆ ಆಯ್ತು, ಸೇಮ್ ಫ್ಯಾಮಿಲಿ ಆಯ್ತ್ರಿ. ಅವ್ರ ಹತ್ರ ಕೇಳ್ತಾ ಇದ್ರಿ, ಈ ಸೆಡ್ ದಟ್ ಇಟ್ ಇಸ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್. Yes. On what ground you have challenged this? But ultimately, claimant is not responsible. To direct the appellant herein to deposit the 50% of the award amount with interest. Now I am in the urgent need of said amount for a medical family. Which is this MSc, Mr. 158. What is the direction? 158. Entitled to compensation amount 1 lakhs with interest. Who are the claimants? Mother. Entire amount release ಮಾಡಕ್ಕೆ ಹೇಳಿದಾರಾ? ಇಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಅಲ್ರಿ, ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ರು? Entitled to the compensation so and so 50% has to be released, 50% has to be deposited. ಈಗ ಎಷ್ಟು ಒಟ್ಟು ಆಗಿರೋದಷ್ಟು 12 lakhs ಮಾಡಿದಾರಾ? ಅದರಲ್ಲಿ ಈಗ 4 lakhs I will permit you to release. IA1 of 2021 is filed for withdrawing that amount deposited before tribunal for the reason stated in that accompanying affidavit. IA1 of 2021 is allowed. The claimant in MEC 158 of 2015 is permitted to withdraw 4 lakhs rupees. The tribunal is directed to release that 4 lakhs in favor of Devamma. Alandre Devamma, the claimant in MEC 158 of 2015 after due verification. Accordingly, IA disposed of. FD li ಇಟ್ಟಿರ್ತಾರೆ. Yes. Week's time is granted to do the needful in respect of Other R2 to pay the process to issue notice to R2. Call this matter along with that so and so. Yes.
Number 5, raise NR for appellant, Ashok and party.
Yes. Notice to R1 is dispensed. 21 days delay is condoned. Ready? Ready, Mr. Rash? 8 years. Hmm. 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 Pain and suffering 1 lakh. Now, if it is above 10, then it becomes 3 lakhs. Where is the discussion of the doctor? In support of this so and so, immediately after that, he has taken to that category hospital, PW1, whole body 14 to that, again, so and so, the number of patients so and so. Why? What is the reason for tribunal to come to that 9%? To fix that on basis of that Master Malikarjun, they have come into that 9%. It should be more than 10%. That is the only point. Yes. It has to be 3 lakhs instead of 1 lakhs. Other this thing is correct. ಅದರಲ್ಲಿ ಅಷ್ಟೇ ಫಿಕ್ಸ್ ಮಾಡಿದಾರಲ್ಲ 25,000 3,75,000 ಕೊಡ್ಬೇಕಂತ ಹೇಳಿದ್ದಾರೆ. Medical expenses as it is, so only this we can enhance. Mister, either you have to rely on that Master Malikarjun or you have to argue separately. Avaga 3 lakhs barala. Avag we have to assess. ಮಾಡಿದ್ರೆ ಇದು ಒಂದರಲ್ಲೇ ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಅದರಲ್ಲಿ 25 ಮೆಡಿಕಲ್ 25 ಒಟ್ಟು 1,75,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ನಿಮಗೆ 1,20,000 ಆಯ್ತ್ರಿ. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ದಾರೆ? ಅಲ್ಲ, ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ದಾರೆ? ಯು ಸಿ ದಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮಿಸ್ಟರ್. Lump sum they have given 25. That's what I said. If you want, I will pass an order, or I will secure the records. Yes, that's all. Tell. So and so, Learned Council appearing for the claimant has contended that due to that extent, at the time of the extent, claimant was aged about 8 years. What she was doing, mister? She was studying. He was studying. Yes, he was studying in 3rd standard. Due to that extent, he has suffered grievous injury. He has examined doctor as PW2. In his evidence, he has deposed that the claimant has suffered 43% disability to lower limb and 14% to that whole body. The tribunal has assessed the whole body disabilities is 9% is on lower side. He further contended that the compensation awarded by the tribunal in the other hand also on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Patil Learned Council appearing for the insurance company has contended that the tribunal, after considering that the evidence of the doctor and injury suffered by the claimant has rightly assessed the whole body disabilities 9%. Considering that evidence of doctor and documents produced by the claimant and medical records, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Perot's judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 29/10/2018 due to rash and negligent driving of rider of motorcycle bearing registration number AA02 EZ 3360. At the time of the accident, the claimant was aged about 8 years. He was studying in 3rd standard. Due to the accident, he has suffered the following injury. He has examined the doctor as PW2. In his evidence, he has deposed that the claimant has suffered disability of 43% to the lower limb and 14% to whole body. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 14%. Since the claimant was in a minor, the apex court in case of Mallikarjun versus Divisional Manager, National Insurance Company Limited and others has held that in case of the disabilities is above 10% up to 30% to that whole body, 3 lakhs has to be awarded for pain and suffering and future loss, mental and physical shock, hardship, inconvenience, discomfort, and loss of amenities of the life. Accordingly, the compensation awarded by the tribunal 1 lakh rupees under that head has to be enhanced to 3 lakhs. The compensation awarded by the tribunal in the other head are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Yes.
for appellant, J. Kumar.
Yes. Notice to R1 is dispensed. 24 days delay in filing an appeal is condoned. Yes. Office is directed to secure original records from the tribunal.
7, PM Siddhappa for appellant, R. Shashidhara, J. Kumar.
Yes. Notice to R1 is dispensed. 425 days condoned, not entitled for the interest. Yes.
8, for appellant, Harini Shivananda.
Notice to R1 is dispensed. 281 days delay condoned, not entitled for the interest. He's not there, madam. We will see next week.
Right.
Is it claimant's appeal?
Yes, my lord.
Yes, yes. Then delay is not entitled for the delay.
HMP for appellant, N. Krishnaswamy.
Compliance of the office objection for 4 times. Acceptance of wakalat of Sri N. Krishnaswamy R4. Notice not at. Why that wakalat has written? Notice is not at order. Office objection comply madilla. Who is that counsel? 3 weeks time is granted to comply that office objection. Finally, 2 weeks time is granted. 2 weeks time is granted to comply that. No, he has not to comply that office objection. I will dismiss it. What to do? Who is that Harish MG? Also, I will dismiss it. It is already 4 times as time has been granted.
Lord, I'm for the appellant.
Yes.
Lord, Lord, what happened is check were deposited the check was given by the insurance company has been lapsed and it was returned to the company. Kindly grant 1 week time, my lord. I will deposit it.
Now that the last 3 occasions matter as posted, you have not appeared. Therefore, I have
Sorry, my lord. Yesterday I could not appear. I was in Kottalam.
Today I have posted to dismiss.
I'm sorry, very
Yes.
fast. Sorry, my lord. Kindly
Net council
grant
for
1 week.
praise week's time to do the needful.
Much obliged, my lord. I will do it, my lord.
11 Sridhara K for appellant, Harish NR.
Non-filing of acknowledgement having deposited before the, you have deposited. Yes, memo dated 25, withdrawing that amount. Ready? Yes, ready, mister. Amount releasing memo is not maintainable now. You have to file an application. Have you seen that new circular? With the circular, with that application, with a reason you have to state. Otherwise, on what ground you are challenging? Then records are necessary. Office is directed to secure. Yes. Heard. Admit. Yes.
Number 12, PM Siddhappa for appellant, O Mahesh, EA Sanmati, A Venkatesh.
Only quantum. Where is Siddhappa BM? Yes. Furnishing. Who is that? Your colleague, mister? Where is he? In the morning also on matter he has not appeared. R2 and R3, R2, R4 owner, Mr. Then we'll dispense. You ask them to file in a memo, mister. Pass off. Can be disposed of. Yes, where is, you can argue. Only this thing. No, that 60% on whom? This is. Oh yeah, then contributor negligence is there. Then he has to argue on that records necessary. Owners are not necessary, but records are necessary. You see that contributor negligence? Yes. Office is directed to secure original records from the criminal.
Number 30, Harish NR for appellant, CR Ravi.
Yes. Yes, CR Ravi Shankar. Ready? Pass out. If he is ready, you can.
For appellant, United India.
United India, Aridira. Madam, you will take. Yes. Notice to R1 is dispensed. R2 served unrepresented. So and so is directed to take notice. The net counsel for the appellant is directed to serve one set of office.
Number 50, SN for appellant, DJ Kumar, Sita Raj.
Yes. Notice. Where is that Girish session? Manjunath NT. Memo for R3 is dispensed. 31 days delay condoned. Ready? Yes. Click. 1. Yes. Huh? Vijay Kumar? Yara? D. Vijay Kumar. You are appearing for whom? There is 2 insurance company. National Insurance Company. Yes, yaar mein liability rada. Then he wants. Yes. He wants 27. Yes. Release this matter of 2 weeks. Yes.
Agree sensitive for appellant, Geeta Raj.
Yes. Dispensation of notice to R2 dispensed. 27 days delay condoned. Ready, madam? Hmm. Hmm. Aged about 35 years. Yes. The permit it would be, doctor has mentioned 15th of his whole body, but in view of the particular circumstances, of the case, there was no functional disability. It's not. It's not ends on the basis of his entire evidence. It is by 7%. ಡಾಕ್ಟರ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಲಿಂಬ್ ಡಿಸಬಿಲಿಟಿ ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ Yes. Yes. Huh? 2018 extent. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅದು 2018 18 ಅಂತ ಅಂದ್ರೆ 12. Yes. How many days you are in that hospital? No medical bill is produced. Then yes, mister. Note already 45% disability and doctor medical certificate doctor idu bill ಏನು ಇಲ್ಲ ಅಂತಂದ್ರೆ how can who is that doctor, mister? Not in a single bill. You have not suffered any this thing. ಒಂದೇ ಒಂದು ಬಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ ವೆದರ್ ಯು ಹ್ಯಾವ್ ಮೆಟ್ ವಿತ್ ಅನ್ ಆಕ್ಸಿಡೆಂಟ್ ಆರ್ ನಾಟ್. Yes, mister. What is this? Doctor from which hospital he is? Yes. No medical certificate, nothing. Huh? ಹಾಸ್ಪಿಟಲ್ಗೆ ಅಡ್ಮಿಟ್ ಆಗಿರೋದಕ್ಕೆ ರಿಎಂಬರ್ಸ್ಮೆಂಟ್ ಏನು MLC ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಏನಾರ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಲ್ಲ ಎರಡು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ. ಹಾ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಏನದು ಇನ್ಪೇಷಂಟ್ ರೆಕಾರ್ಡ್ ಏನಾಗಿರುತ್ತೆ ಏನು ಇದೆಯಾ ಕ್ಲಿನಿಕಲ್ ನೋಟ್ ಅಂದ್ರೆ ಆಮೇಲೆ ನೀವು ಡಾಕ್ಟರ್ ಹತ್ರ ಹೋಗಿರೋ ಕ್ಲಿನಿಕ್ಗೆ ಮತ್ತೆ ಆಯ್ತು. We can assess 10% and income. That's all. Only 2 heads you can. Other head, there is no documents. How can you that? Later period, hinge assess ಮಾಡ್ತೀರಿ ಎಷ್ಟು ದಿನ ನೀವು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ಅನ್ನೋದೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ, ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಏನೂ ಇಲ್ಲ. Tribunal has rightly assessed that 7% because no documents. ಡಾಕ್ಟರ್ ನಾಗರಾಜ್ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಅವ್ರದೇ, ಬಿಲ್ಲು ಅವ್ರದೇ. ಅವ್ರು ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ ಕ್ಲಿನಿಕ್ ಹೋದಾಗ್ಲಾರು ಒಂದ್ ಮಾತ್ರೆ ಬರ್ಕೊಟ್ಟಿಲ್ವಾ? ಅದು ಇಲ್ಲ. ಎಸ್ ಮಿಸ್ಟರ್, ಏನಿಲ್ಲ ಅಲ್ಲ ಅಲ್ಲಿ. ಆಯ್ತ್ರಿ, ವಾಟ್ ಈಸ್ ದಟ್ ಮಿಸ್ಟರ್? 25,000 ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಫುಡ್ ನರಿಶ್ಮೆಂಟ್ ಕನ್ವೆನ್ಸಸ್ ನೀವು ಹಾಸ್ಪಿಟಲ್ ಇದ್ರೆ ತಾನೆ, ಏನು ಆಗೇ ಇಲ್ಲ ಅಲ್ಲಿ. ನಥಿಂಗ್ ಹ್ಯಾಸ್ ಬಿನ್ ಹ್ಯಾಪನ್ ಮಿಸ್ಟರ್. Otherwise, he could have produced some documents. Medical expenses, loss of income during that later period. Sri Jagadish, HT Learned Council appearing for the claimant has contended that at the time of the accident, he was earning 15,000 per month. Tribunal has assessed notional income of the claimant as 8,000 per month is on lower side. Further contended that he has examined the doctor as PW2. In his evidence, he has deposed that the claimant has suffered 43% disability to limb and 15% to whole body. The tribunal has assessed the whole body disability 7% is on lower side. Further contended that due to that extent, the claimant has suffered grievous injury. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities on lower side. The tribunal has failed to grant any compensation for loss of income during the later period and food and nourishment. Hence, he sought for enhancement of compensation. For contra, the Gita Raj Learned Council appearing for the insurance company has contended that even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed notional income of the claimant as 8,000 per month. She further contended that considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed the whole body disability is 7%. Lastly, she has contended that the claimant has not produced single medical document to show that he was inpatient and he has been treated in Sanjay Gandhi Hospital and Sports Hospital. Yes. Yes. Therefore, the tribunal rightly has not granted any compensation in the other hand. Therefore, she contended that considering that injury suffered by the claimant and considering that evidence of doctor, the overall compensation awarded by the tribunal is just and reasonable. Or the Learned Council for the parties, Feroz, judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 25/1/2018 due to rash and negligent driving of rider of motorcycle bearing registration number KA05 HY1512. Due to that accident, the claimant has suffered the following injury. He has examined the doctor Nagraj has PW2. In his evidence, he has deposed that the claimant has suffered 3% disability to particular limb and 15% to whole body. The claimant has not produced single documents related to the admission in that hospital, or he has undergone any surgery and produced any medical bill. Consider under these circumstances, I am of opinion that the whole body disabilities can be assessed 10%. Even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2018, the notional income has to be considered as 11,000. At the time of 12,500. At the time of the accident, he was aged about 37 years. Yes, multiplier applicable to that age group is 15. Accordingly, loss of future earning has been reassessed as follows.
10%, 2,25,000.
Yes. Due to that extent, the claimant has suffered the above said injury. He was inpatient for he has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life, considering that evidence of doctor and injury suffered by the claimant, as well as the compensation awarded by the tribunal for pain and suffering, loss of immunities and just and reasonable. The claimant is entitled for 8,000 for food and nourishment and conveyance attendance charges. The other hand, compensation awarded by the tribunal is just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified.
Serial number 70, Sripati Shastri for appellant, P.B. Raju.
Yes, Shastri,
Sripati Shastri 17,
notice to R1 dispensed. 48 days delay condoned.
serial number 18 adjourned. Serial number 90, Vishwanatha Pujari K for appellant, United India.
United India are there. You are there, Mr. Huh? Janardhan Reddy. Notice to R1 is dispensed. Delay of 118 days is condoned. R2 served unrepresented. Janardhan Reddy is directed to take notice. At the request of the parties, refer the matter to Lok Adalat.
Serial number 20, Vishwanatha Pujari K for appellant.
Extremely sorry, my lord, extremely sorry. Serial number 17, actually, I am on leg in serial number 17.
Next,
Serial number 17.
17 adjourn ಆಗಿದೆ sir. Memo delay condone.
Sorry, extremely sorry, my lord.
yes.
Serial number 20,
United India Insurance ಯಾರು ಇದ್ದೀರಾ? Shivanagoda. Yes. Notice to R2 and R. Serial number 2135 ಆಗಿತ್ತು.
serial number 20, Vishwanatha Pujari K for appellant.
United India, Shivanagoda is there. Shivanagoda is directed to take notice for respondent number 1, 2 and 3. Notice to respondent number 2 and 3 is dispensed. Delay of 125 days is condoned. At the request of the parties, refer the matter to Lok Adalat.
Jai Sanmati for appellant.
Yes. Deposited before the tribunal. ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ? Yes. Learned counsel for the appellant suggests that he has deposited the entire compensation amount before the tribunal. Submission is accepted. Office objection is overruled. What is that matter? Issue notice. Yeah. Order date. Judgment and award dated 25th November 2021 passed by MACT Kolar in ECA number 6 of 2018. A period of 3 months. What is that? Huh? ಯಾವ್ದ್ರಲ್ಲಿ? ಎಷ್ಟಾಗಬೇಕದು? Learned counsel for the petitioner appellant submits that by typographical error, in the appeal memo in substantial question of law D, there is the sum of rupees has been typed as instead of 5,84,800, it is 4,24,500. Accordingly, is permitted to correct the same.
Look at the application matter, serial number 22, Ashok Patil for appellate.
ಅದು ನೋಟಿಸ್ ಸ್ಟೇ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ಅದನ್ನ ಆರ್ಡರ್ ಮಾಡಿ ಪರ್ಮಿಟೆಡ್ ಟು ಕರೆಕ್ಟ್ ಆಗ್ತದೆ. What is this, Mr. Served unrepresented? Delay of 4 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Heard, admit, because they have served unrepresented. Yes.
Appellate, universal shampoo.
Universal shampoo ಯಾರಿದ್ದಾರೆ? You are there, Mr. Note, there is a delay of 307 days in filing an appeal. IA 1 of 2019 is allowed. Delay of 307 days is contemplated for the interest. Respondent number 1 is served unrepresented. 2 is served unrepresented. B. Pradeep is directed to take notes.
For appellate, B. Banu Prakash.
Yes, Ganesh. Condone the delay. You have any objection? There is a climate appeal. There is a delay of no, this is appeal filed by that climate. You are appearing for that KSRTC. Yes. Delay of 309 days. Condone not entitled for the interest. Yes. He is not there.
Number 25, for appellate, Swami.
Yes. Delay of 100 days in filing an appeal. Climate appeal. Yes, delay is condoned. Yes, ready? Yes. The counsel for the appellant submits that this appeal may be filed along with its own. Yes.
Number 26, Arjan. Serial number 27. Shankar Prasad, MD for appellant, PC Shivannegowda.
Yes. Ready? Yes. Delay of 309 days is condoned not entitled for the interest. ಎಷ್ಟು ಏನ್ ಮಾಡಿದೆ ಯಾವುದು MEC 2 ಇದೆಯಾ this is MEC 6097 page para 18 issue number so W1 ಎಲ್ಲಿಂದ ಶುರು ಆಗುತ್ತೆ in respect of this MEC para 18 through that FIR complaint that is for this thing. Where is the evidence of the doctor? Doctor has been not examined. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಎಷ್ಟು ಕೊಟ್ಟಾರ ಒಟ್ಟು ಟೋಟಲ್ ಕೊಟ್ಟಿದಾರಪ್ಪ ಆರ್ಡರ್ ಬರ್ತಾನೆ. ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದಾರೆ? ಏನ್ ಯಾವ ತರ ಆರ್ಡರ್ ಬರ್ತಿದಾರ? ಎಲ್ಲ ಆರ್ಡರ್ ಯಾವ ಕ್ವಶನ್ ಎಲ್ಲಿದ್ಯಪ್ಪ? ಓಹೋ ಈ ತರ ಎಲ್ಲ ಮಾಡಿದಾರ. 1,34,000 1,44,000 40,000 ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗು ಆಕ್ಚುಯಲ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 1,44,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಡಾಕ್ಟರ್ನೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲಲ್ಲಪ್ಪ. ಆಯ್ತು, ಅದನ್ನೆಲ್ಲ ಡಾಕ್ಟರ್ ಹೇಳ್ಬೇಕಲ್ಲ ಎಷ್ಟು ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ ಅದರಲ್ಲಿ ಏನು ಅಂತ. ನಾವೇನ್ ಡಿಸೈಡ್ ಮಾಡೋದು? ಎಸ್ ಮಿಸ್ಟರ್, ವಾಟ್ ಕೆನ್ ಬಿ ಅವಾರ್ಡೆಡ್ ಇನ್ ಅಡಿಷನ್ ಟು ದಟ್? ಎಸ್, ವಿಲ್ ಮೇಕ್ ಇಟ್ ಆಸ್ 2 lakhs. 1,44,000 ಇದೆ, ರೌಂಡ್ ಫಿಗರ್ 2 lakhs. ಆಯ್ತಪ್ಪ, ಹೆಂಗ್ ಅದಕ್ಕೋಸ್ಕರನೇ ಒಂದು ಗೆಸ್ ಮಾಡ್ಕೊಡ್ತಾರ. ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇದ್ರೆ ವಿ ಕ್ಯಾನ್ ಸಿ ಹೌ ಡಾಕ್ಟರ್ ಸೆಡ್ ಹೌ ಇಟ್. ಆಯ್ತು, ಯು ಹ್ಯಾವ್ ನಾಟ್ ಎಕ್ಸಾಮಿನ್ ದ ಡಾಕ್ಟರ್. ಮತ್ತೆ ಯಾರು ಹೇಳ್ಬೇಕು? ಅಗ್ರೀಡ್ ಆಯ್ತು, ದೆನ್ ಐ ವಿಲ್ ಫಿಗರ್ 2 lakhs. ಎಸ್, ಏನೇ ಇಲ್ಲಪ್ಪ. ಆಯ್ತು, ಅವೆಲ್ಲ ಡಾಕ್ಟರ್ ಹೇಳ್ಬೇಕು ಇದಾಗಿದೆ, ಇದಕ್ಕೆ ಇಷ್ಟು ಬೇಕು ಅಂತ ಹೇಳ್ಬೇಕು. ಎಸ್, ಅಲ್ಲಿಗೆ 55,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಇಫ್ ಯು ವಾಂಟ್ ಐ ವಿಲ್ ಡೂ ಇಟ್, ಅದರ್ವೈಸ್ ಎಸ್, ವಿಲ್ ಸೆಕ್ಯೂರ್ ದ ರೆಕಾರ್ಡ್ಸ್. Office is directed to secure original records from the tribunal.
Serial number 28 Arjun, serial number 29 KP Bhuvan for appellate, Harini Shivananda.
Yes. 55 days delay is controlled. Yes. Where is the discussion?
Serial number 2.
Yes. ಹನ್ನೆರಡು 36 ಕರೆಕ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ. 12%. ಆಯ್ತು, ಬರೋಣ. 13% ಕರೆಕ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 8,500. ಈಗ ಎಷ್ಟು ಕೇಳಿದ್ರಿ? 24 years. 2018 ಅಂತ ಅಂದ್ರೆ 12,500. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರಿ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್. ಎಸ್, towards amenities, nourishment, medical expenses during the later period. Yes, madam, that's all.
Loss of future income 12,000.
3. KP Bhuvan, Senate Council appearing for the claimant has contended that due to that extent, claimant has suffered grievous injury He was inpatient for a period of 24 days. 12 days. He has suffered a lot of 12 days. He has examined the doctor. Doctor has assessed the limb disabilities is 36%. Whole body disabilities is 18%. The tribunal has assessed whole body disabilities 12% is on lower side. He further contended that at the time of the accident, the claimant was earning 20,000 per month. Tribunal has considered the notional income of the claimant as 8,500 is on lower side. Lastly, he has contended that due to that accident, the claimant has suffered the previous injury. He was inpatient for a period of 12 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unearthiness throughout his life. The compensation awarded to the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Srimati Harini Shivanand, Learned Counsel appearing for the insurance company, has contended that even though doctor has deposed that claimant has suffered whole body disabilities is 18%, since the limb disability assessed by the doctor is 36%, the tribunal has rightly assessed the whole body disabilities 12%. She would further contended that even though the claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,500. She further contended that the injury suffered by the claimant is in minor in nature. He was inpatient for a period of 12 days. Considering that evidence of doctor, the injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses are just and reasonable. Lastly, she has contended that the interest awarded by the tribunal, 8% is on her side. Hence, she sought for dismissal of the appeal. Heard the learned counsel for the parties, arose judgment and award. Not in dispute, the claimant has suffered an injury in a road traffic accident occurred on 17/11/2018 due to rash and negligent driving of driver of car bearing registration number KA09Z5787. Due to the accident, the claimant has suffered the following injury. He has examined the doctor as PW2, PW3. In his evidence, he has deposed that the claimant has suffered the limb disabilities is 36%. The whole body disabilities is 18%. Considering that the evidence of doctor and injury suffered by the claimant, that rightly assess whole body disabilities 12%. The claimant has claimed that he was earning 20,000 per month. He has not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. The accident occurred in 2018. The notional income has to be considered as 12,500. At the time of the accident, he was aged about 24 years. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows.
1%, 3 lakhs.
Due to that extent, the claimant has suffered the above said injury. He was inpatient for a period of 12 days. He has suffered a lot of pain during the treatment. Considering that the evidence of doctor, injury suffered by the claimant, I'm inclined to enhance the compensation for pain and suffering from 45,000 to 60,000. Loss of immunities from 25,000 to 40,000. Loss of income during the later period for 3 months. The enhanced compensation amount carries 6%. Accordingly, the abuse is allowed in part. Yes.
Number 30, Girish Baladare for appellant, Ravi Samprati.
Yes. Condone delay. Delay 3 days is condone. Yes.
Number 31, Vishwanatha K for appellant, C. Shankar Reddy.
It's very security. Ready. Pass on. Yes. Release this matter next week.
Number 32, M. Ananda for appellant, Sriram Chandra Insurance.
Sriram General Insurance.
Number 32, Sriram Chandra.
Who is that? There is a delay of 176 days in filing an appeal. IA 1 of 2021 is filed for condonation of delay. Delay is condoned, not entitled for the interest. Respondent number 2 is served unrepresented. P. Pradeep is directed to take notice. 32. You are appearing for GM Anand. Yes, you serve the copy. Yes.
33, Muhammad Umar Farooq.
IA 1 of 2022 is dismissed as not pressed. Yes, Mr. What is notice? I thought, yeah, on what ground you are challenged? Ala, either insurance policy. Ultimately, pay and recovery, you have to pay 50% deposit. Yes, heard. Issue notice. Day of judgment and award dated 29th December 2020 passed by MA City Nelmangla is state subject to condition. Appellant has to deposit 50% of the award amount before the tribunal before 8 weeks.
Swami for appellant.
DA 2 of 22 dispensation of why you have produced in the other case. Yes. IA 1 of 2022 is allowed dispensed for production of certified copies of the judgment. Yes. Notice. One stay. Day of judgment and award dated 31st December 2019 passed in MEC. You have MEC? MEC 1213 of 2015 subject to deposit the entire compensation amount with interest before the tribunal within 4 weeks from today.
35,
Same entire amount. Delayed. Entire amount with 4 weeks.
number 41, Janardhan Reddy for appellant.
Only quantum. Why? Notice they depositing entire amount before the tribunal within 4 weeks.
Number 42, Eli Gangadharappa for petitioner.
Yes, Gangadharappa.
42, petition matters. Number 43, K. Veena for appellant. Yeah, Lakshmi Narayana.
Milad, I am Lakshmi Narayana appearing.
Yes, where is that? Kevin,
Number 43,
Yes, Milad, I am here.
yes. On what ground they have challenged Mr.
It is only for quantum, Milad. Enhancement of seeking enhancement compensation.
Yes. Case of death,
Death, Millard. Yes.
there is no dispute in respect of liability.
No, Millard. No, Millard. 2009 accident.
2000.
Yeah, 2009.
Yes.
5,000 should be taken as income.
Yes. Entire share to the paid to him. Yes. ಅವರೆಷ್ಟು ಕೇಳಿದಾರಪ್ಪ ಇನ್ಕಮ್ ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ
One minute.
salary was thus he was getting a salary of 8,000, 2,000 data.
4,000 rupees taken.
Working as a conductor.
5,000 should be taken.
Yes, 45 years.
25% should be taken. Future prospects.
Yes.
6,250 plus 1/4.
1/4.
1,562 minus the total net amount 4,688 million
Yes.
into 12 into 14.
Yes. Yes, we'll redo it.
Yes, Millard. Yes, Millard.
Yes. So and so, Learned Council appearing for claimant has contended that at the time of the accident, deceased contended that deceased was working as a conductor and he was getting a salary of rupees 8,000 per month plus 200 rupees quota. The tribunal has assessed the notional income of the deceased as 4,000 per month is on lower side. He further contended that in view of judgment of apex court in case of Pranay 25% of the income of the deceased has to be added for future prospects. Lastly, she has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 44,000 each. Hence, she sought for enhancement of compensation. For contra, Sri Lakshmi Narayana, here Learned Council appearing for, even though the claimant has claimed that deceased was working as a conductor and he was getting salary of rupees 8,000 plus 200 rupees bata. He has not produced any document to establish the same, except producing the salary certificate. He has not examined. Hence, the tribunal has rightly assessed the notional income of the deceased as 4,000. He further contended that since the claimant has failed to establish that income, the tribunal has rightly not granted future prospects. Lastly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Or the Learned Council for the parties peruse judgment and award. It is not in dispute. Narayana Raju died in road traffic accident Akkada 10/2/2009 due to rash and negligent driving of driver of the bus bearing registration number AA014239. The case of the claimant that at the time of the accident, deceased was working as a conductor and he was getting 8,000 rupees per month and 200 rupees bata. The tribunal has assessed the notional income of the deceased as 4,000. Considering that the evidence of the parties and material available on record, in my opinion, the monthly income of the deceased can be assessed as 5,000 per month. In view of judgment of apex court in case of Pranay Sethi, 25% of the income of the deceased has to be added for future prospects. The tribunal has rightly deducted 1/4 of the income of the deceased for personal expenses. At the time of the accident, the age about 45 years. The multiplier applicable to that age group is 14. Accordingly, loss of future earning has been reassessed as follows.
1,250 minus 1,562 at the rate of 4,688, 4,688 into 12 into 14, 7,87,584.
In addition, 16,500 for loss of estate, 16,500 for criminal expenses. Who are the claimants, Mr.? First is wife, then sons, daughter, parents. Yes. Yes. The first claimant is entitled 44,000 for spousal concern in view of judgment of apex court in case of Megma. The first claimant is entitled 44,000 for spousal consortium. 2 and 3 is entitled 44,000 each for parental consortium. 4 and 5, 44 each for filial consortium. Hardly, the appeal is allowed in part. In view of order dated 24/2/2015, the claimant is not entitled for the interest for a period of 173 days.
Number 44, Sitaramarav. 44.
Yes, who is that BL Kumar? And what is that only quantum? Also,
45, CSI AC for apparent, Babu Mahendra, B. Pradeep, apparent.
Babu Mahendra, B. Pradeep. Lingraj has spent a notala. ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ ಹಾಕಿಲ್ಲಲ್ಲ ಅವರು ಕೊಟ್ಟ ತಕ್ಷಣ ವಕಾಲತ್ ಹಾಕಲ್ಲ ನೀವು Office is directed to delete the name of B. Pradeep for respondent number 2. So the name of N. Lingraj, HS Lingraj for R2. Yes, release this matter next week.
46, for apparent, N. Krishna Swami, Sanjay Kumar.
Yes. What is this, Mr. Krishna? Oh, you are there. Yes. Sridhar DS, pass off.
Number 47, various Samprati for appellant. This is Chivramu, Bharat L.
Yes, Samprati, what is this? TCR kept below. Will admit. Yes, admit.
Number 48, Gandhi Chandrachud for appellant. C.R. Ravishankar.
Yes, Chandrachud.
49 Arjun. Serial number 50, Nagaraj RC for appellant, appellant Shabali.
Nagaraj RC. So,
Antaraj K for appellant, Geeta Raj.
there is that. She was there in that pass-off. ಇದ್ರು ಬೆಳಿಗ್ಗೆ ಯಾವುದೋ ಒಂದು ಮ್ಯಾಟ್ರಿ ಪಾಸ್ ಔಟ್
52 Arjun, serial number 53, Sanat Kumar KM for appellant, Lakshmi Narayan C.
Yes, Sanat. Lakshmi Narayan.
Yes.
Case of death. Yes. No liability dispute. Mr. Samprati. Lakshmi Narayan C. Who is Lakshmi Narayan C? ಸ್ವಲ್ಪ ಹಿಂಗೆ is good. I will discuss. It's a depth case we'll discuss.
Actually,
2018. Yes.
looking as a driver.
Yes.
Trying to be
Yes.
the criminal considered 7,500.
Yes.
Age was considered as 40,000, 25% to 20%.
ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ಕಮ್ ಮಾತ್ರ ಕಡಿಮೆ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲ ಯಾರ್ಯಾರು ಕ್ಲೈಮೇಟ್ಸ್? Wife. Why that tribunal has taken only 1/3? Ah. 1/4 correct ಇದೆಯಲ್ಲ? Correct ಇದೆಯಲ್ಲ? See, except income, loss of dependency is correct. ಇನ್ನ ಬಾಕಿದ್ದು ಅನೌನ್ಸ್ ಮಾಡ್ಬೇಕು. Yes. What about that interest 9%? Yes. See, Sanat Kumar, liability dispute illala? Insurance company appeal ಏನಾರು ಇದೆಯಾ? ಚೆಕ್ ಮಾಡಕ್ಕೆ. Sri Sanat Kumar, Senate Council appearing for the claimant has contended that at the time of the accident, deceased was earning 20,000 per month as a driver. The tribunal has assessed notional income of the claimant as deceased was ಎಷ್ಟು ತಾಂಡಿದ್ದಾರೆ? 7,500 is on lower side. He further contended that in view of judgment of apex court in case of magma, the claimants are entitled 44,000 each. Hence, he sought for enhancement of compensation. For contra, Sri Lakshmi Narayan C. Learned Council appearing for insurance company has contended that even though the claimant has claimed that deceased was earning 20,000 per month, they have not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the deceased as 7,500. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. But a learned counsel for the parties arose judgment and award. It is not in dispute. What is the name of the deceased? Somanna died in road traffic accident occurred on 11/7/2018 due to rash and negligent driving of driver of car bearing registration number KA02 MC 3347. Even though the claimant has claimed that she was earning 20,000 per month, they have not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2018, the notional income has to be considered as 12,500. The tribunal has rightly added 25% of the income of the deceased for future prospects and rightly deducted 1/4 of the income of the deceased for personal expenses. The multiplier applicable to the TH group 40 is 15. Accordingly, loss of future earning has been reassessed as follows.
3,500, 3,125 at the rate of 25%, 15,625 minus 3,906 at the rate of 1/4, 11,790, 11,790 into 12 into 50, 21 lakhs, 9,420.
In addition, 16,500 for loss of estate, 16,500 for criminal expenses. In view of judgment of apex court in case of lastly, he has contended that insurance company, the interest awarded by the tribunal 9% is in view of judgment of apex court in case of Magma, the first claimant is entitled 44,000 for spousal consortium. Claimant number 2 and 3 are entitled 44,000 each for parental consortium. Claimant number 4 is entitled 44,000 for filial consortium. The enhanced compensation amount carries 6% interest. Hardly, the appeal is allowed in court.
Cell number 55, Manjunath ND for appellant.
They have said that there is one more connected matter. I have connected matter post along with that connected matter. What is the warrant? 27. 27. Yes. 27 post.
55, Manjunath ND for appellant. Who is Jay Kumar?
Yara. Non-filing of the acknowledgement for having served a copy. Yes. Learned counsel for the respondent has submitted that he has received that copy, appeal copy. Hence, office objection is overruled. For this matter up to 2 weeks.
Number 56, Manjunath ND for appellant. P. Pradeep.
Ready? Hmm. 2016, huh? Yes. Hmm. Hmm. See, 9,500. Correct and correct. Very good finding. Para number 20. Read. The driving license. Driving license. Yes. Only on the basis that you don't have a driving license. That cannot be. It will settle law. What do you say about that? Huh? Hmm. Hmm. Parents suffering ಕೊಟ್ಟಿದ್ದಾರೆ immunities future income of 2 years towards the convenience management conveniences. ಅದೆಲ್ಲ ಸರಿ ಇದೆ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ what you say about 10% contributory negligence? %10 contributory on your part that you are not having holding any driving license. Huh? Yes. Tell. What's your name, mister? Yes. So and so learned counsel appearing for the claimant has contended that the accident is occurred due to the negligence of the driver of auto bearing registration number KA55 5003. The tribunal is error and held that the claimant has contributed 10% to the accident just because he is not holding a driving license. This finding of the tribunal is contrary to material available on record. In respect of quantum, he has contended that at the time of the accident, the claimant was earning 18,000 per month. Tribunal has assessed notional income of the claimant as 8,000 per month is on lower side. He further contended that Due to that extent, the claimant has suffered previous injury. He was inpatient for a period of 31 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, the Pradeep, learned counsel appearing for the insurance company, has contended that the claimant was driving that vehicle not holding valid driving license, and he was not aware how to drive the two-wheeler. He has contributed to the extent 10%. Therefore, the tribunal has rightly held that the claimant is not entitled for compensation. I rightly held that he has contributed 10% to the extent. In respect of quantum, he has contended that even though the claimant has claimed that he was earning 18,000 per month, he has not produced any document to establish the same. For the circumstances, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. He further contended that considering that injury suffered by the claimant and considering that evidence of doctor, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses are just and reasonable. Hence, he sought for dismissal of the appeal. Lastly, he has contended that the interest awarded by the tribunal 9% is on their side. Or the learned counsel for the parties. There was judgment and award. It is not in dispute that the claimant has suffered an injury in a road traffic accident occurred on 8/9/2016 due to rash and negligent driving of driver of auto bearing registration number KA 555003. The case of the claimant that on 8/9/2016 at about 8 p.m. when he was riding that motorbike bearing registration number KA 11 R5829 on left side of the road, when he reached near Vishat Ampapura village on Mysore Mahadevpura road, Patna Taluk. At the time, the driver of auto bearing registration number KA 555003 drawn the same in rash and negligent manner and dashed to the petitioner motorbike. Due to impact, he fell down and sustained injury. So, through his case, he has examined himself as PW1 and examined Dr. Ravikant as PW2 and Dr. Vijay Kumar as PW3. And he has produced 82 documents. In his evidence, he has reiterated that the accident is occurred due to the sole negligence of driver of auto bearing registration number KA 555003. The tribunal, only on the ground that the claimant has not holding driving license to drive the motorcycle, has come to the conclusion that he has contributed 10% to the accident. This finding of the tribunal is contrary to the material available on record, unless it is proved that the rider of the motorcycle was rash and negligent he cannot be held to be guilty of contributory negligence. The apex code in case of Sudhir Kumar, Sudhir Kumar Rana versus Surendra Singh and others. Paragraph 9 and 10 exactly. As held, where it was held as follows. In view of the above position, I am of the opinion that the finding of the tribunal that the claimant was contributed 10% to the extent is without any basis. The finding to that effect is set aside, and it is held that driver of the auto wearing registration number so and so is solely, it is alone is held negligent, rash and negligent in causing that accident. In respect of quantum, due to that accident, the claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed whole body disabilities 9%. Even though the claimant has claimed that he was earning 18,000 per month, he has not produced any document to establish the same. The circumstances, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. At the time of the accident, he was aged about 40 years. The multiplier applicable to the age group is 15. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 31 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 30,000 to 50,000. Loss of income during the later period for 3 months. Tribunal has 4 ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. I am inclined to enhance the compensation for loss of immunities. The compensation awarded by the tribunal, in the other hand, are just and reasonable. The enhanced compensation amount carries 6% interest. The insurance company is directed to deposit entire compensation amount trust within 6 weeks from date of first.
7, Ravin Kumar for appellant, Janardhan Reddy.
60, 56. Ready? Heading. ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್? Read. Where you are reading? Para 23. With regarding that permanent disability. Read. ಇಪ್ಪತ್ಮೂರು ಪ್ಯಾರಾ. ನೀವೇ ಹೇಳಿದ್ರಿ ಪ್ಯಾರಾ 23 ಅಂತ. But 23 ಫಸ್ಟ್ ಇಂದ ಓದ್ರಿ. ಪೇಜ್ ಅಲ್ರಿ, ಪ್ಯಾರಾ 23 ಇಲ್ವಾ? ಅಲ್ದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? Is it not a judgment copy? 23ನೇ ಓದಿ ಅಂತ ಹೇಳಿದ್ದು. ಎಕ್ಸಾಮಿನೇಷನ್ ಈ ಫೌಂಡ್ ದಟ್, ಎಸ್ ಅದನ್ನೇ ಓದಿ. Yes, Mr. How can you take that 1/3? It is in a degree. Doctor evidence ಇದೆಯಾ? ಅಲ್ಲ ಆಯ್ತ್ರಿ, ಏನ್ ಡಾಕ್ಟರ್ ಅವರು? ವೆದರ್ ಈಸ್ ಎನ್ ಆರ್ಥೋಪೆಡಿಕ್ ಆರ್ ಎ ನ್ಯೂರೋಸರ್ಜನ್, ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಉಂಟೇನ್ರಿ? ವಿಲ್ ಸೆಕ್ಯೂರ್ ದಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಿಕಾಸ್ ಸೀರಿಯಸ್ ಇಂಜುರೀಸ್ ಇಸ್ ದೇರ್. ವಿಲ್ ಸಿ office is directed to secure original records from the tribunal.
Number 59, Janathan Reddy for appellant.
Yes. Notice. Now there are two claim petition. What about other? You are not challenged. Then how can you say that liability, Mr.? You have already filed other appeal also. Yes, heard. Issue notice. What is the date of that judgment, Mr.? Sixth ಅಲ್ರಿ, ಅದೇನೋ 11th 10th ತಿದ್ದದಂಗಿದೆಯಲ್ಲ. ಇದು ಸಿಗ್ನೇಚರ್ 11/8/2022 ರೀ. Yes. Day of judgment and award dated 11/8/2022. caused by MECT Bangalore in MEC 1901/2018, subject to deposit of 50% of the award amount with interest within 4 weeks from today before the tribunal.
Clearing matter, serial number 60, which are ready for appellate, Gopal Krishna N.
Pass out. Ready? Yes, ready. Yes. Record putting. This is the case where that income and this is just we will recollect first 15,000 as a salary of cable company and agriculture income. 50,000. The criminal has taken 12,000. 2018. Then next dispute in respect of deduction. Yes. One fourth. Tribunal has taken 1/3. It should be 1/4. Yes, that's all. The income will reassess. Yes, will reassess. Only the dispute is in only two. Yes, yes. I have marked it. Yes. 3. Chandraj, Learned Council appearing for the claimant has contended that at the time of the accident, what is his age? 52 years. 52 years. He was working as a technician in Faison Digital Cable Service Limited, and he was getting a monthly salary of rupees 15,000. In addition to that, he was having an agriculture property, and he was totally earning 50,000 per month. He contended that he has produced salary certificate exhibit E12. He has also produced that identity card issued by the company as exhibit P13, and he has examined that co-employer as PW2. The tribunal, without considering this aspect of the matter, has error in considering the monthly income of the claimant as only 12,000. He further contended that there are 4 dependents. The tribunal has deducted only 1/3 for personal expenses instead of deducting 1/4. Lastly, he has contended that future prospects kotidara 8%, 25%, 40%. He further contended that in view of judgment of apex court in case of Magma, the claimants are entitled 44,000 each. Hence, he sought for enhancement of compensation. For contra, Srimati Geeta Raj, Learned Council appearing for the claimant insurance company has contended that even though the claimant has claimed that deceased was working in case on digital cable service and he has produced the salary certificate and he has examined that the co-employer, but he has not produced any bank statement to show that he is receiving 15,000 per month. Considering that evidence of the parties and material available on record, the tribunal has rightly assessed the notional income of the deceased as 12,000 per month. She further contended that since the claimant number 4, father is, which is the claimant number? Yes, claimant number 4. 4 is that Srimati Dayakamantu. Claimant number 3. 3, the father of the deceased has his own income for his livelihood. He is not depending upon the income of the deceased. Therefore, the tribunal has rightly deducted 1/3 of the income of the deceased for personal expenses. Lastly, she has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. The interest awarded by the tribunal, 7% is on their side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute. H.P. Manjanath died in road traffic accident occurred on 11/2/2018 due to rash and negligent driving of driver of bike bearing registration number KA06 EJ2661. The claimants have claimed that deceased was, what is his name? Manjanath. Yes, Manjanath, son of Vasraj. Yes, has contended that deceased was working as a technician in KSR Digital Cable Service, and he was getting a monthly salary of 15,000 rupees. They have produced salary certificate as exhibit P12, and they have also produced that ID card issued by that KSR Digital Cable Service as exhibit P13, 14, 13, 12 and 13. Yes, identity card as 14, as 13 another. Yes, produced as exhibit 14. They have also examined co-employer as PW2. The claimant has not, even though they have deposed that he was getting a salary of 15,000 per month, except that salary certificate, he has not produced that any bank statement. In addition, the claimant is also claiming that the claimant has claimed that deceased was having an agriculture income, and he has produced as a agriculture income. Considering that evidence of parties and material available on record, I am of the opinion that the monthly income of the deceased can be assessed as 15,000 per month. The tribunal has rightly considered 25% of the income of the deceased, 40% of the income of the deceased for future prospects. The multiplier applicable to the there are 4 dependents. The claimant in his evidence, PW1 in his evidence has categorically stated that the claimants are entirely depending upon the income of the deceased. The cross-examination of PW1, nothing worthwhile has been elicited from the respondent. Therefore, the 1/4 of the income of the deceased has to be deducted for personal expenses. The multiplier applicable to the age group is 17. Accordingly, loss of future earning has been dependency has been reassessed as follows.
15,000 plus 6,000 at the rate of 40%, 21,000 minus 5,250 at the rate of 1/4, 15,750. 3,750 into 12 into 17, 32 lakhs, 13,000.
In addition, 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of magma, the first claimant is entitled 44,000 for spousal consortium. Claimant number 2 is entitled 44,000 for parental consortium. 3 and 4 is entitled 44,000 each for filial consortium. The enhanced compensation amount carries 6% interest. Secondly, the appeal is allowed in part. $16,500.
In the hearing matter, serial number 61, O Mahesh for appellant. Mr. Nagaraja,
Yes, Mahesh. So,
52, Pradeep Naik here for appellant. This is Shivanya Gowda.
where is that Pradeep Naik? Yaru Pradeep Naik. None appear. Release this matter after 2 weeks.
Kalyan R for appellant. R. Om Kumar.
Kalyan, you are appearing for. Yes, R. Om Kumar. He's in the panel now. Mr. R. Om Kumar, I think he is not there now. Halad, but it has to be continued, or what is that? ಏನಿದು dismiss ಆಗಿದೆ. What to do, Mr. Anybody will take notice, or it has to be continued in his name? Last occasion, so many times he has not come. If it is case for remand, we can remand it. Next week. Yes. Yes, that is your responsibility. On your this thing, I am granting the time. Because all this 2012, either way, yes. Release this matter next week. You just verify, Mr. Take that number. Yes.
Yes, Umesh for appellant.
Pass over.
Babu for appellant. Yes, difference from me.
Yes. What is this? Polygonal. Is there any dispute regarding the liability? Yes. 2009. Yes. 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 From 9/12/2009 to 12/12/2009. How many days?
3 days. 9
3 days.
9/12 2009 to 12/12/2009. Just got examined. He was treated at Masa. The whole state injury. Operated to right clavicle with plates, screws, and other injuries were treated conservatively. Later, he was discharged on 12/12/2009. These are advised to follow up in more detail. Right forward. And back on the examination, please follow the right shoulder.
What is doctor evidence?
If you are successful, you can write up on 99.8%. Future operation, your report has awarded rupees 10,000 rupees to 30,000. And you need to-
What are the injuries? Complaint pain, right shoulder, unable to move that right shoulder. Yes, shoulder injury. Upper limb 45% ಹೇಳ್ತಾರೆ into divided by 4 ಆದ್ರೆ ಎಷ್ಟಾಯ್ತು?
11.25.
12%. Here the cross examination. Yes, where is that? Colleague ಯಾರೊಬ್ರು ಇದ್ರಲ್ರಿ ಇಲ್ಲಿ? That overall documentary evidence based on. ಅಲ್ಲ ಅವ್ರ ಕಲಿಗ್ ಒಬ್ರನ್ನ ಎಲ್ಲೆಲ್ಲ ಬಿಟ್ಟಿದ್ರಲ್ಲ ನಮ್ ಕೋಟಿಗೆ ಒಬ್ರು. Yes. Yes, Mister. What you say that? Yes, Mr. Krishna sir. ಅಪೀಲ್ ಇದೆಯಾ? ನೋಡಿ ವೆರಿಫೈ ಮಾಡಿ ಕ್ರಾಸ್ ಅಪೀಲ್. ಸರ್ ಇದು ಅಪೀಲ್ ಇದೆ, ಕ್ರಾಸ್ ಅಪೀಲ್ ಇದೆ. What about that? No, has the climate has been appeared? Yes, Mister. What is the finding regarding that, this thing? Have you challenging that compensation also, Mr. I will see that finding if they said that whatever is awarded is.
The circumstances may be more reasons for what
So that in both cases, you counsels are appear. Why you are not asking to club that matter? This is like even you are also party. Yavat this was agidado. By the time you are also there in this matter. 16 or wakalat yavagattu. Then you have filed an. It is 2012, huh? 14. Yes, both are aware that there is an appeal is pending by that. Then you have to file an application for recalling that order. Otherwise, we cannot enhance in this. There cannot be a two different judgment on the same this thing. No, that not that consent of you both. See that the effect of the judgment. If one court said compensation is just and proper, can I enhance that compensation? That it has been confirmed. Yes. You file an application. Huh? No. Why you have not said that your appeal is pending, Mister? As on that day it is pending. You have also filed in 2012. What is the serial number? Oh, same council. Same council. Mate. Yes, Mister. No, you have to file in a review. No, that is not that advocate on record's fault, not on your client. That is your fault. See, it is a case for enhancement, but you have not. See, the ground which he has urged is consider you are intoxicated, therefore that negligence is not on the part of the insurance company. That is their contention. If that is upheld, then it is different. That has been negative. Then that case for enhancement. But you, for your negligence, the parties have suffered. But to you are the same counsel who has appeared. Case ಜಾಸ್ತಿ ಆದ್ರೆ ಹಿಂಗೆ ಯಾವ ಕೇಸು ಎಲ್ಲೆಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಂತ ಗೊತ್ತಾಗೋದಿಲ್ಲ. Yes, ಆಯ್ತು ನೋಡೋಣ. Anyhow, let's see that ultimately party will be affected, Mister. Let's verify what you have to do. The request of counsel for the appellant to reach this matter next week. This was like they have to file an application.
Connected matter.
Yes. Raju, where is Paso? Yado. Okay, Ilva. Like he is there, we'll see. Other side is third representative. Or are a colleague. 2012 matters. ಏನು ಇಲ್ಲ, I don't know why that 2012 matters ಏನೋ ಲಯಬಿಲಿಟಿ ಅವೆಲ್ಲ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ಏನೋ ಇದು ಪೆಂಡಿಂಗ್ ಅಂತ. ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಕೆಲವಲ್ಲ ಏನೂ ಇಲ್ಲ, ಬರೀ ಇದ್ರ ಮೇಲೆ ಕ್ವಾಂಟಮ್ ಒಂದು 25-30 ಸಾವಿರ ಮೇಲೆ ಪೆಂಡಿಂಗ್ ಇದಾವೆ. ಎಸ್ ಪಾಸ್ ಅವರ್ ಲೆಟರ್ ಸಿ ದಟ್. ಎಸ್ ಮಿಸ್ಟರ್ ನಾಗರಾಜ್, ದಟ್ ಲಿಂಗರಾಜ್ ಹ್ಯಾಸ್ some problem today. Said it will tomorrow, na? It is urgent tomorrow. Yes, Mr. Ravishankar, which is your man? Serial number? Harish NR. Notice to R1 is dispensed. Delay of 65 days is controlled. Yes, it will come. Office is directed to secure original records from the field. 48 ಏನಾಯ್ತು? ready ilva? Yes, at the request of council for R1, release this matter next week. Yes, madam. No, you are appearing for that. No, climate or an insurance company or owner. Owner. No, is it related to the motor vehicles? Then why you have moved before this court? Is it my roster? What is that classification? You don't know anything. Yes. Then no urgency. If it is not my roster, how can I consider, madam? No, I will tell me that which is that this thing classification. Then I have to read and tell. Yes. Yes, Mr. Which is that? 46 230. Yes. 230 will. I think 230. There is no other matter. Therefore, yes.
Sir, court officer.
Court officer at 68 ಅಜ್ಜನ ಆಯ್ತಾ or passed over?
Sir, 64 ಏನಾಯ್ತು sir? Court officer.
ಹೇಳಿ ಸರ್.
64 sir.
64 ಪಾಸ್ ಓವರ್.
Sir, okay, mention ಮಾಡ್ತೀನಿ. Okay, thank you.
ಓಕೆ ಸರ್. ಇಲ್ಲ ರವಿಶಂಕರ್ ಸರ್ ಮಾಡಿದ್ರು, ಬಟ್ ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಸರ್. ಕೇಸ್ ಇಲ್ಲ ನನಗೆ ಮಧ್ಯಾಹ್ನದ ಮೇಲೆ ಅಂತ ಕೊಡ್ಲಿಲ್ಲ.
ಹೇಳ್ತೀನಿ. ಅಲ್ಲ ನಾನು ಹೇಳಿದಲ್ಲ, ಒಂದ್ ಸ್ವಲ್ಪ ಹಾಸ್ಪಿಟಲ್ ಓಡಾಡ್ತಾ ಇದ್ದೀನಿ, ಬರೋದ್ ಲೇಟ್ ಆಗಿ ಮಿಸ್ ಮಾಡಿದೆ, ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡ್ಲಿಲ್ಲ. ಓಕೆ
ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ, ಮಧ್ಯಾಹ್ನ ಮಾಡಿ ಸರ್. ಓಕೆ. Number.
उसका चालू
इसके फैन का आवाज
30 230 matter Serial number 69.
With my kindly, my lord. 64. Hospital ಓಡಾಡ್ತಿದ್ದೀನಿ. I could not mention in the morning, my lord. ಒಂದು ಇನ್ನೊಂದು 3-4 ದಿನ ತೊಂದರೆ ಇದೆ. Next week your lordship or week after next I will be able to.
Which matter, Mr.
64 respondents ಯಾರು ಇಲ್ಲ. ಸರ್ವ್ ಆಗಿದೆ ಅಷ್ಟೇ.
Yes, at the request of council for the applicant, release this matter of rules.
Admission 230 matter, serial number 69. Sumani Nagaland for petitioner. Bali Karnataka, Hamid Ahmad.
Yes.
Sir, mute ಮಾಡ್ಕೊಳ್ಳಿ.
Yes, yes. How much time you require to that committee? No, that we will dispose of. Now, after disposal, how much time you require to take a decision? Yes, within 3 months you have. Yes, I will modify that. See, Sri Lanka Learned Council is appearing to the chief, so and so. Then to submit that to grant some time to respond to complete that process in view of the above petition. It is for respond direct to complete the process of claiming the special rules for service within in view of the petition. Now we'll do one thing. Now that State of Karnataka registry. Now, what is that? Suppose if rule committee place the matter before the rule committee for framing the rules, then what will be that further this thing? If rule committee has taken a decision that there cannot be any rules for absorption of this, then it has to be placed before that full court. No, suppose if rule committee said no, rules cannot be framed. No, that will be placed before full court. It has to be accepted or it has to reconsider or not. You complete all this process within 6 months. Now, I said to frame the special rules for absorption of within 6 months. We'll say that let that second respondent take a decision on their representation in accordance with law within 6 months. Within 4 months. Even then, that is also that suppose if committee has taken a decision saying that it cannot be, rules cannot be framed, let that full court is also take a decision within 1 month. I will grant 4 months outer limit. See, only that clarification is only in respect of the para 5 now. You said we'll complete the process 6 months in accordance with law. Yes. I will say that complete that process within 4 months from today. Yes. No, therefore, I am saying that, no, wait, this only within 4 months, second respondent to complete the process. I am not in respect of the government, let us see that later. That will not, because now that whether rules is, it will be approved or not. If it is, see, ultimately, if that High Court has approved, then government will pass. But I will say that second respondent has to complete that process within 4 months from today. Yes. Now that's petitioner. Yes. Yes. Now that only the petitioner. Yes. Shri, what's your name, Mr. Prashant Murthy. Prashant Murthy. The net counsel appearing for the petitioner submitted that the petitioner has not undertaken to frame the special rules for absorption of the petitioner within 6 months. They have undertaken only that within 6 months, the request of the petitioner will be considered in accordance with law. Therefore, he sought for modification of order dated 27th January 2022. The counsel for the respondent has no objection for modifying to that effect. Accordingly, order dated 27th January 2022 is modified to that effect. Modify that. Instead of the direction given in the para 5 has been to be deleted. The petitioner herein is directed to, have they given a representation? Yes. Petitioner herein is directed to consider that representations of the petitioner in accordance with law. Respondent herein in accordance with law, not later than 4 months from today. With that observation, the review petition is modified. You decide in accordance with law. If you rejected it, then they have a remedy. If it is allowed, then it will be placed before the government. If government has delayed, then they will file another petition with them. Yes. To that effect, we will modify. Yes. 4 months from today. Yes.
Pending applications.
All pending applications are disposed of. Yes.
Matter number 2, serial number 9, Harish MG for appellant, N. Krishnaswamy.
Yes, what is this, Mr. Non-compliance of office objection 4 times? What is on 19/4/2021, 2 weeks time is granted to comply the office objection. On 14/7/2021, again, finally 2 weeks time is granted to comply the office objection. The office objection has not complied. Even on 20/12/2021, 3 weeks time is granted to comply the office objection. The office objection is not complied. Even when the matter is called today, even today, the office objection is not complied. The matter is called today, morning session, none appear for the appellant. It is called in second session also, none appear for the appellant. It appears that appellant is not interested in prosecuting that appeal. Hence, appeal is dismissed for not.
Number 42, Gangadharappa AV for petitioner.
Yes, Mr. Huh? Next week. Yes, at the request of counsel for the petitioner, release this matter of 2 weeks. Next week and only 2 days. Yes.
Number 40.
Today I am free. I could have argued what is there. Decided. Yes, madam. You are there. Government advocate. Yes. 21, Mr. Second November. Yes.
Serial number 44, D.L. Kumar for appellant, D.C. Sitaram Rao.
Yes.
Serial number 44,
D.L. Kumar. Password.
serial number 46, Sridhar D.S. for appellant.
Yes,
N.
Mr.
Krishna Swamy.
In this case, I accept claimants, my lord. Appellant
Yes.
claimants appeal for enhancement of the award. My lord.
Yes.
Case of injury,
Yes.
the date of accident is on 1/12/2016, my lord. In respect of the injury sustained by the appellant has sustained proximal tibia fracture left grade 5, satiated and other injuries for which the tribunal has awarded 50,000 rupees as pain and suffering.
What is that doctor has deposed, Mr. regarding that disability?
Disability to the left lower limb at 28% and to the whole body at 14%. my lord.
Where is that discussion?
Discussion is at
40% of the whole body. How much tribunal has considered?
tribunal has not considered because it continues to work subsequently also. Therefore, in my respect, one submission is that in respect of permanent disability report, tribunal ought to have ordered some amount, my lord. Having regard to the decision reported in 2011 ACJ 1971, where the apex court has considered permanent disability has to be awarded, my lord.
What is that judgment?
2011 ACJ 1971, page number.
Sir, 2011 SCC 1971.
ACJ 1971.
Parties.
Part is P. Kodandapani versus Tamil Nadu State Transport Corporation.
Yes. No, even then you require judgment is let us see now.
Para number 12 and 13.
Yes.
It is stated the compensation for loss of earning power capacity has to be determined based on various aspects, including permanent injury disability. At the same time, it cannot be construed that compensation cannot be granted for permanent disability of any nature. For example, take the case of a non-earning member of a family who has been injured in an accident and has sustained permanent disability due to amputation of leg or hand. It cannot be construed that no amount needs to be granted for permanent disability. It cannot be disputed that apart from the fact that the permanent disability affects the earning capacity of the person concerned, undoubtedly one has to forgo the other personal comforts, and even for normal avocation, they have to depend upon others. In the case on hand, two doctors had explained the nature of injuries, treatment received, and the disability suffered due to partial loss of eyesight and amputation of middle finger in the right hand, and we have already adverted to the avocation, namely at the time of the accident, he was working as a foreman in Armstrong Hydraulics Limited. Taking note of this nature for partial loss in eyesight, loss of middle finger of the right hand, it not only affects the earning capacity but also affects the normal avocation and day-to-day work. In such circumstances,
that is what the loss of immunities. Loss of immunities is for only. Loss of immunities is granting that. Other inconvenience you are suffering.
Well, apart from loss of immunities, in respect of
loss of immunities under loss of what is the meaning of loss of immunities?
that is
Other
what-
difficulties he has suffered due to the disability, any loss suffered, loss of earning they will granted. Pain and suffering. Immunities is for that only.
permanent disability has to be awarded at the
permanent disability name.
Earning capacity affects the earning capacity of the injured, but he has to also forgo personal comforts and he has to depose.
That is what
on others.
amenities is that only. For other difficulties he was facing in his life. Amenity matenik mate. And what are head that amenities and unhappiness is granted.
The submission is that apart from amenities, disability has to be avoided. In respect of disability has to avoid.
No, see, Mr. Disability is in respect of your earning. Amenities or disability. Either one of them has to be argued. This is one and the same. Amenities and disabilities, which is awarded for the persons who has not suffered any loss. Under that head only it has to be awarded. Then pain and suffering and amenities, other conveniential heads, it has to be considered in your case. Yes, Mr. What is that? What are the injury, Mr. Sridhar?
Proximal tibia fracture of left grade 5, sciatica and other injuries. Para number 9, internal page 7. Last sentence. Petitioner took treatment and sustained a knee fracture, tibia and fibula.
Para number
9, internal page number 7.
Records ideyala kodi. Bone grafting about so. Plus the petitioner has taken a treatment. Tibia and fibula.
Further PW only. In the middle of the further PW has reported that the petitioner has sustained proximal tibia fracture left grade 5. Sciatica underwent open section and fixation of iliac bone graft.
Pain in left knee, difficulty in squatting, climbing, staring, difficulty in so on. Tenderness over the left knee, restriction of the joint movement, fracture with implants. Yes, Mr. That's all. Yes. Yes, in hospital. How many days you are in that hospital?
He was inpatient for 6 days. Between 2016 to 7/20/2016.
Yes. See the net council appearing for the climate has contended that due to the extent the climate has suffered grievous injury. He has examined the doctor as PW2. In his evidence, he has deposed that the climate has suffered 28% left lower limb, 14% whole body disabilities. Due to the disability, it is difficult for the petitioner to due to the disability, petitioner is suffering pain in left knee, difficult to squatting, climbing the upstairs, stand an affected limb and difficult to do routine activities. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses on lower side. Hence, he sought for enhancement of compensation. For contra, what's your name, Mr. Shashi? Shashi Shekhar, Learned Counsel appearing for N. Krishna Swami, submitted that. Even though doctor has deposed that the claimant has suffered 14% whole body disability, due to the disability, the claimant has not suffered any future loss of income since he has continued in his service. Therefore, the tribunal has rightly not granted any compensation under that head. He further contended that considering that injury suffered by the claimant, considering that evidence of Dr. B.R. Ramesh and considering that wound certificate and medical discharge summary, the tribunal has granted a just and reasonable compensation for pain and suffering, loss of immunities, other incidental expenses. Hence, he sought for dismissal of the appeal. Heard a learned counsel for the parties, Feroz, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 1/12/2016. Rash and negligent driving of driver of Tata Suma bearing registration number KA0312. Due to that accident, the claimant has suffered the following injury. He has examined the doctor. Doctor has deposed that the claimant has suffered 14% whole body disability. Since the claimant has continued in his job and there is no loss of future earning, the tribunal has rightly not granted any compensation under the head. Due to that accidental injury, the claimant has suffered. Due to that accident, the claimant has suffered grievous injury. Due to that disability and injury, he is complaining that pain in the left knee, difficult to squatting. Doctor, the claimant has examined the doctor. Doctor has deposed that he has suffered 25% disability to left lower limb, 14% to whole body. He further deposed that due to the disability, the claimant suffering a pain in left knee, difficult to squatting, climbing upstairs, stand an affected limb, difficult to do routine activities. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the compensation awarded by the tribunal for pain and suffering has to be enhanced from 50,000 to 70,000, 75,000. Loss of immunities has to be enhanced from 30,000 to 60,000. For conveyances, attendance and nourishment charges has to be enhanced from 30,000 to 45,000. to 50,000. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Yes. Insurance company is directed to deposit compensation amount. Yes.
Much appreciated.
What is this matter, Mr. What? Is it serial number? ನಾಗರಾಜ್ ಹೆಗ್ಡೆ ಅಂದಿರ್ತಾರಲ್ಲ,
ಇನ್ನೊಬ್ರು ಆ ಲೇಡಿ ಬರ್ತಾರೆ, ಮಂಜುಳಾ ಕಲಿಗೆ.
liability, there is no dispute. What is the date of the accident? 2016. What is that income they have claimed? 3000. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್? 4000 ತಗೊಂಡಿದ್ದಾರೆ. 4000 ತಗೊಂಡಿದ್ದಾರೆ. 7000 has been taken. 9,500. MEC ಯಾವ್ದಿದು? 508. 21 years. Doctor who has treated the injury because of treating injuries, treatment, tumor, proximal, weakness, more surgery, one more surgery, 25. 29,000 red lower limb, produce the disability certificate, X-ray deposit. Correct ಅಂದಿದ್ದಾರೆ. ಇನ್ಕಮ್ ಜಾಸ್ತಿ ಕಾಣಬೇಕು. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರು? 15 days. Pain and suffering, loss of immunities, medical expenses, income during the treatment period. ಮೆಡಿಕಲ್ ಬಿಲ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು? ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರಾ? So and so, learned counsel appearing for the claimant has contended that at the time of the accident, he was earning 15,000 per month. The tribunal has considered monthly income of the claimant as 7,000 per month is on lawyer side. He further contended that, yes, madam. Yes. Yes. Take 2 minutes time. Yes. Take your one time. Yes. 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 ಹ್ಮ್ 15,000 ಕೊಟ್ಟಿದಾರಲ್ಲ.
So if they're having 29%, 10% is whole body weight.
Yes. 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 Food and nourishment ಕೊಟ್ಟಿಲ್ವಾ? ರನ್ನಿಂಗ್ ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಫುಡ್ ಅಂಡ್ ನರಿಶ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ. Yes, we'll consider. That's all. So and so, the council appearing for the climate has contended that at the time of the accident, climate was earning 15,000 per month. The tribunal has considered notional income of the climate as 7,000 per month is on lower side. She further contended that due to that accident, the climate has suffered grievous injury. He was inpatient for a period of 15 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. She further contended that the tribunal has failed to grant any compensation for food, nourishment, and attendance. Lastly, she has contended that due to that accident, the climate has suffered grievous injury. He has undergone surgery. Doctor deposed that he required 25,000 rupees for removal of implant. The tribunal has granted only 15,000. She sought for enhancement of compensation. For contra, she doubly Resident Council appearing for corporation has contended that even though the climate has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Other circumstances, the tribunal has rightly assessed the notional income of the claimant as 7,000 per month. He further contended that the injuries suffered by the claimant are minor in nature. He was inpatient only for a period of 15 days. The tribunal, considering that the evidence of doctor and injuries suffered by the claimant, has granted a just and reasonable compensation for pain and suffering, loss of immunities, other incidental expenses. Lastly, he has contended that even though doctor has deposed that the claimant required 25,000 rupees for removal of the implants, he has not produced any estimation in respect of future surgery. Considering that injuries suffered by the claimant, the tribunal has granted a 15,000 rupees for future medical expenses is just and reasonable. Hence, he sought for dismissal of the appeal. The learned counsel for the parties peruse judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 16/2/2018, 31/10/2016. Then one sorry, Yes. Due to the rash and negligent driving of driver of ASRTC bus bearing registration number KA40 F763. Due to the accident, the claimant has suffered the following injury. He has examined. Who is the doctor? PW3 na? Kutswami has PW3. In his evidence, he has deposed that claimant has suffered 29% right lower limb. The criminal, considering that evidence of doctor and injury suffered by the claimant, has rightly assessed whole body disabilities 10%. Even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. In such circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2016, notional income has to be considered as 9,500. At the time of the accident, he was aged about 21 years. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, the claimant has suffered above-said injury. He was inpatient for a period of 15 days. He has suffered a lot of pain during the treatment. He has suffered with disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 50,000. Loss of immunities from 30,000 to 40,000. Loss of income during the later period for 3 months. The claimant is also entitled for compensation under the head of food, nourishment and attendance charges of ₹10,000. The compensation in respect of future medical expenses is concerned, considering that injury suffered by the claimant, the tribunal has rightly granted ₹50,000. Compensation granted in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows.
Number 60, HR Renuka for appellant, N. Gopalakrishna.
Yes, where is that? He is not coming. On what ground they have challenged, Mr. How that accident has occurred? Now that manner of accident at about 90 near Godadal village gate, when the petitioner herein was proceeded on his motorcycle bearing also in the West Konar Road, a KSRTC bus bearing was driven a driver from the opposite direction to Malu Taluk, that's a negligent manner, so and so. FIR, they have not challenged all this thing. Now they are saying that bus is not involved. Yes. But he admitted. What he said. Yes. No, but their own suggestion they have made. Yes, which paragraph? Yes. I alone driving that motorcycle on that day, along with that on left side of the road, KSRTC bus came from opposite directions and right side. There was not other vehicles going ahead that motorcycle. It's false to suggest that I tried to overtake that another vehicle which is going ahead of me, and in doing so, dashed to the motorcycle opposite coming from the KSRTC bus. Then it is admitted that there is an accident between that. Then the fixing is not whether he is negligent or not is the only question. Yes. Where is she? She is not coming at all. One appear for the upland. Release this matter. Yavat next to be open. Tomorrow. Yes, release this matter tomorrow.
Number 61. Mahesh for appellate.
Yes, Mr. He is not. He has not come. What to do? Huh? Only enhancement. We'll see our pretty file. Password ಆಯ್ತಲ್ಲ ಅದು? ಕೊಡಿ. Case of injury. MEC. Which MEC this is? 765. Lacerated or wounds. 23.
20th September 2009.
Yes.
He had suffered 3 injuries, all of them are simple injuries.
Yes.
Laceration to the right foot, laceration to the right knee, and swelling to the right hand.
Yes.
Disability 4% of the full body 10% and the laceration.
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? %10 ತಗೊಂಡಿದ್ದಾರಾ? Yes. 30%, therefore, that is the disability, 1/3, 10% correct ತಗೊಂಡಿದ್ದಾರೆ. There is no dispute regarding the disability. Income is set 8,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ. 2009 ಅಂತ ಅಂದ್ರೆ 5,000 ತಗೊಳ್ಬೇಕು. Age 18 multiplier. How many days he was in that hospital? Teacher due disability. Amenities. Yes, we'll consider, we will enhance some marginal. Three. E.L. Kumar, learned counsel appearing for the claimant has contended that at the time of the accident, the claimant was earning 8,000 per month. The tribunal has considered the notional income of the claimant as 3,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. He has examined the doctor. Doctor has deposed that claimant has suffered 30% disability to the particular limb. The tribunal has assessed whole body disability is 10% is on lower side. Lastly, he has contended that due to the accident, the claimant has suffered grievous injury. He was inpatient 3 days. He was inpatient for a period of 20 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Anup, learned counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 8,000 per month, he has not produced any document to establish the same. In the absence of documentary proof, the tribunal has rightly assessed the notional income of the claimant as 3,000 per month. He further contended that the injuries suffered by the claimant are minor in nature. Even though doctor has assessed 30% disability, it is only in respect of particular limb. The tribunal has rightly assessed the whole body disabilities 10%. Lastly, he has contended that the injuries suffered by the claimant are minor in nature. The tribunal, considering that evidence of doctor and injuries suffered by the claimant, and considering that wound certificate and medical bill, has granted a just and reasonable compensation for pain and suffering, loss of immunities, other incidental expenses. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 20th/9/2009 due to rash and negligent driving of driver of tractor trailer bearing registration number AA 16T5485/5486. Due to that accident, the claimant has suffered the following injury. He has examined the doctor as PW2, PW3. In his evidence, he has deposed that the claimant has suffered disability to 30% to the particular limb. Considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities 10%. Even though the claimant has claimed that he was earning 8,000 per month, he has not produced any document to establish the same. In the absence of any documentary proof in respect of income, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2009, 5,000 has to be considered. At the time of the accident, he was aged about 23 years. Multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 20 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 20,000 to 35,000. With loss of immunities from 5,000 to 25,000. Conveyances, travel allowances has to be enhanced from 5,000 to 8,000. Loss of income during the later period has to be granted for 2 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as.
Home Mahesh for appellate, Mr. Nagaraja. Yes.
None appears. Release this matter of position.
Raju for appellate.
Ready? Yes, Mr. Raju. Yes, Mr. Pradeep. Urgent. Morning, I think nobody is there. It is urgent. 62, it is urgent. Exhibit P6 ಕೊಡಿ. For this matter, 37.
ಸ್ಟಾಪ್ ಆಯ್ತು ಅನಿಲ್ ಪೆಂಡಿಂಗ್ ಇದು ಮೇಡಮ್ ಅಪ್ಲೋಡ್ ಏನಿಲ್ಲ ಅಲ್ಲ ನಾಳೆದಲ್ಲ ಇದು ನೀವು ಮಾಡ್ತಾರ ಚೇಂಬರ್ ಹಂಗೆ ಕೊಡ್ತಿದ್ದೆ ಸೈನ್ದು ಹಂಗಂದ್ರೆ ತಿರ್ಗಾ ಇದು ಚೇಂಬರ್ ಅಲ್ಲಿ ಕೊಡ್ತಿದ್ರಪ್ಪ